When a business is conducted from leased premises and the business is to be sold, the written consent of the landlord to the assignment of the lease from the current business owner to the buyer is generally required under both the business sale contract and the lease. I'm John Gallagher from Argon Law, and I'd like to share a few things about the process and consequences of assigning a lease of real estate in Queensland. A landlord can't unreasonably withhold its consent to a proposed assignment, although the lease will often place an onus on the tenant to satisfy the landlord that the proposed assignee has both the business experience and the financial capacity to operate the business. The landlord's consent is commonly given in the form of a deed, which also contains a covenant from the assignee to comply with the terms of the lease. But just because the consent is given doesn't mean that the outgoing tenant is automatically released from ongoing liability under the lease. Unless the landlord agrees to such a release, the outgoing tenant can be held responsible for breaches of a lease if the new tenant defaults after the business has been sold. There is an exception to this in the case of a lease entered into after the 2nd of April 2006, which is regulated by the Retail Shop Leases Act. In that case, an outgoing tenant is automatically released, but only if certain disclosure requirements under that Act have been complied with. It's very important that all parties are mindful of the disclosure requirements of the Retail Shop Leases Act and to seek legal advice if they have any doubts about their obligations in that regard. Please don't hesitate to contact me if you have any questions about commercial or retail leasing. And if you found this video useful, please subscribe to our video blog and take a look at our website.